Welcome in, Clark County. I'm Rob Anderson with Reform Clark County. And today we're going to be taking a look at the rules and procedures that are now on the table before the county. And for a mysterious reason, they want to add removal powers into their rules and procedures. Wonder what that's all about. And also, I jumped in on public comments and made a comment that Sue Marshall got a little defensive about. We'll talk about. And then also, anti-ICE activities are afoot in Clark County, and it's coming. A resolution is going to be talked about soon. So that's what we're going to talk about. Come on in to Reformcast. So it's that kind of boring time of year when the Clark County Council goes over rules and procedures. That's like their bylaws, how they're going to go about things. And they want to add removal language, and which I brought up in my public comments about this issues. But what they want to do is add removal powers that they can remove councilors from their committee assignments. I wonder what that's all about. Maybe because they removed Councilor Belkot last year because they knew that she was going to be the deciding vote that would kill light rail. And Mayor Ann and Sue Marshall jumped into action and proceeded to remove Councilor Belkot because of how she was going to vote. And so lawsuits have moved forward. Of course, a Skamania report came out, and they want to add these removal powers. So my question that I posed is, why now? Because in federal court, they've made the case, Clark County has made the case that they acted legally. They have removal powers innate in the either charter or in some other way, but what they did was legal. But for some reason, now we are in January 2026, and they want to add removal powers into the rules of procedures so that they can remove councilors, maybe if they don't like how they might vote, like what happened last year. And so they want to add that. To me, that's kind of like an admission of guilt, potentially, that, hey, what we did last year, we didn't really have legal authority to, so maybe we should add those rules in there. So that's what's happening. So another thing that came up is that they want to not necessarily eliminate invocation, prayer, and the pledge like they tried last year. Will Fuentes, Sue Marshall, and some others made comments that they wanted to get rid of invocation and prayer. Glenn Young, Matt Little, backtracked on that. They changed their side. And but this year, it's come back up in a little bit quieter way, maybe a little smarter way if they're wanting to get rid of it someday. And that is now, instead of just being on the front part of the meeting, they want to move it to kind of a pre-meeting stage. So invocation, prayer, the Pledge of Allegiance, they're wanting to move that it happens before the meeting, right before, which just kind of feels like maybe this is just, typical incrementalism where little by little we'll get what we want, maybe not in the big bite, but in little bites. And so they're moving it out of the meetings, but on the front end of the meetings. So take a listen to what they're proposing.
Next item on there is Pledge of Allegiance before proclamations, and it was also brought to my attention if we're going to do that, maybe moving invocation as well prior to proclamations on the agenda.
Chair?
Yes, go ahead.
Yeah, I may have brought this one forward. I actually would like to do the pledge and the invocation before we do any work. I just think it's a good way to get a meeting started, to reflect on what we're doing and how we do it. I just think it's a good way to start it. And we shouldn't do any actions before those two actions.
I would agree with that.
I support that as well. I think it's very consistent with a lot of other boards that we sit on. Pledge of Allegiance, invocation. Well, we all know how I feel about invocation, but for now, we'll keep the Pledge of Allegiance and the invocation. We'll keep the Pledge of Allegiance and the invocation. We'll keep the Pledge of Allegiance and the invocation. Clerk Count today, make sure you mention that.
So we'll want to keep an eye on that because that was a big deal last year. I think that they're still determined to remove these things, and this could be just a small step towards that. Something else that happened in this meeting is that during public comments, I made a suggestion. About a new for their rules and procedures, and so take a listen to what I said.
I think it's important also to add language in your rules and procedures that all counselors should cooperate with any law enforcement investigation. As you know, and some of the public knows, for the counselors, the county manager did not cooperate with the Skamania investigation into what happened last year. And that's unfortunate. That should not happen. As you sit there as counselors, I think that you have a duty and obligation to go above and beyond for serving the people that you represent. So I hope at this stage, at least, you'll weigh and measure that kind of idea, that thought, and hold a high standard to your office. Thank you very much.
So it doesn't happen often, but after public comments, Sue Marshall made kind of the unusual comment, and it was rather defensive, I thought, in which she addressed my suggestion about adding a rule that counselors, county officials, have to cooperate with law enforcement investigations, in particular if they're involving county business. It just kind of makes sense. But she got a little defensive, and this is what she said.
And I'd just like to clarify for the record, there's no one on staff or of the council that has refused to cooperate with law enforcement. So I just want to make that clear.
So since she's made this claim, I think this is important to maybe take a time out and take a look, review the tape, as they say, in football terms. Let's go under the hood and take another look at this play. And so Sue Marshall is making this comment that, that they did not refuse to cooperate. But back in 2025, late June 23rd, the Skamania detective did contact county staff requesting interviews. On the next day, June 24th, he sent an email that specified all the dates, multiple dates in July that he would be available for interview that would work with him. Now, mind you, he was not looking to have joint interviews with multiple counselors. So this wasn't like a logistical hurdle where you had to get all four and the county manager in the same room at the time, which could be logistically challenging. This was just individual interviews. So for almost 60 days, nothing happens. In fact, the detective details this in his report, 13-page report, of how this was kind of stalled. He was just kind of giving excuses and, well, this and that, and vacations and so forth. And what we can see from the public records side behind the scenes, we see that this request from the detective was kicked to the county manager. The county manager sends it to their attorneys, and then there's just nothing. There's just nothing for over the entire month of July. So all of those request dates that the Skamania detective gave went silent. Nothing happened. And then, August rolls around, and from the public records side, August 12th, I believe it was, where the county manager finally responds to the county staff saying, okay, let's do these interviews. And then there's also more back and forth for 2-3 weeks. And then finally, the detective has to move on to other investigations. He's concluded that they're just not going to cooperate. In fact, I know that he was wondering if they would cooperate at all. He wasn't he wasn't sure if they would cooperate. And so that's what he did. He moved on and let them know, we're not going to do this. So, in his report, he says, based on the delay to the injunction hearing and the delays with the interviews scheduled through the county assistant, this investigation has entered a state of temporary pause. So, what did Sue Marshall say?
And I'd just like to clarify for the record, there's no one on staff or of the council that has refused to cooperate with law enforcement. So I just want to make that clear.
So, to review, did the Skamania detective contact Clark County requesting interviews? Yes, 100%. Did the Skamania detective give them ample time? Yes, over 60 days. Did the 4 counselors and the county manager satisfy those requests for interviews? No, they did not. What did Sue Marshall say again?
And I'd just like to clarify for the record, there's no one on staff or of the council that has refused to cooperate with law enforcement. So I just want to make that clear.
Maybe we'll dive into this again a little bit later. So something else that came up in Clark County is, and it seems to be a reoccurring theme, is anti-ICE sentiment and questions, and now it's maybe a potential resolution that might be coming. So if you've noticed throughout the state and really throughout the country, it's getting quite popular, quite bougie to be anti-ICE, and so lawmakers, officials are trying to kind of outdo each other with their anti-ICE statements or resolutions. We've seen it in the city of Vancouver. We've seen it in on the state level, Washington Attorney General, and now it's come to Clark County. Sue Marshall has put on the agenda for January 28th to begin the working out of a anti-ICE resolution. Now, of course, she doesn't state it as such, but it's very clear that's the direction that this is going, referred to the city of Vancouver's recent statement. So we'll have to keep an eye on this, because will they try to up Vancouver and show that they're more anti-ICE than they are? Who knows? But we'll want to keep an eye on this and see how this develops. So that's Reformcast for this episode. I hope you enjoy it. I hope you like it. You hit the share button. You tell your friends, make comment, whatever you can do. Subscribe if that's a factor. And so if you want to support or be a sponsor of this show, I'd really appreciate it. You can contact me at rob@reformcast.com, and we'll see you next time.